I'm Gillian Triggs, the Dean of the Law School, and it's my very special honour and delight to welcome you to the fourth of these Voiceless lectures that we've been holding here at the Law School. May I particularly welcome our very special guest, Lesli Bisgould. It's wonderful to have you here from Canada. To welcome in particular on Dean, who's been so instrumental in getting this series going, and Brian and all the members of the family. It's wonderful to have you, as well as the growing and very talented staff of Voiceless. Lovely to have you here, and of course, ladies and gentlemen, it's very important for us at the Law School to have you come from a wider community than necessarily lawyers, although I suspect many of you here are lawyers, but very good to have you here in the Law School, and for this quite exceptional evening. I think it's going to be a fascinating lecture and series of commentaries. I wanted perhaps to say how, firstly important, how this topic is for many reasons, particularly what appears to be a growing tension between seeing, in this case, kangaroos or seals as a resource that is to be exploited, but also the management of these, particularly kangaroos, as a pest, and how we manage the environmental ethics with the ethics in relation to dealing with sentient beings. These are very important and difficult questions for the environment in which we live, and we have a growing legal body of law which is attempting to deal with these problems. In particular, I'm very interested, and have been as a public international lawyer, in the role of the rule of law internationally in managing these kinds of questions. And many of you will know that we have a quite unique matter before the International Court of Justice in the whaling case that Australia has brought against Japan. This is a very exceptional thing for a country like Australia to do to a major trading partner. We always try to work with Japan to resolve our diplomatic disputes, but in relation to the so-called scientific whaling under the Whaling Convention of 1946, we've really reached the limit of the level of tolerance for the Australian public and for the Australian government, and we now have a formal application before the court and hopefully some form of adjudication of these questions as to the validity or otherwise of the so-called scientific whaling in the Southern Ocean. So we have an engagement of not only domestic law but international law with managing the tension between exploiting sentient beings and dealing with the ethics of their killing and science and research in relation to them. So I think we're in for a fascinating evening. We have some wonderful speakers. I did want to say, however, that as this is the fourth of the lectures, I've had a little bit of time to think about what's been happening over these few years, and it's really been extraordinary how the interest in animal rights has been developing through the work of Voiceless and other extraordinary programs that you're all doubtless familiar with, the seminal documentary on Four Corners on the live export trade. But as well as these developments in the public area, we are seeing a much greater scholarly research in the area, and we have a work that's available outside for you to look at, but also I wanted to mention, if I may, Spruik as Dean of the Faculty, a work, Animal Law in Australasia, and one of my colleagues, Celeste Black, will be joining the editors for the second edition, which will come out next year. But also we, along with a number of other law schools in Australia, are running a unit at the master's level as an election on animal law. So the area is developing in leaps and bounds, and certainly over these last 4 years, the raising of awareness of the issues within this law school, and I think within Sydney, owe a great deal to the work of Voiceless, and I do congratulate you for that. So if I may then turn over to our MC. Thank you very much for managing this, and I hope you all have a wonderful evening. Thank you very much.